Morning, everyone. Thanks for joining us. If you don't know me, my name's Sean Tiernan. I'm an attorney here at Allcock Marcus. I specialize in condo law and then also conveyances. If you don't know what conveyances are, that's really when you buy or sell a house, get a loan, bank representation, seller representation, buyer representation. And then we have Lisa Vesperman Still. She works at WFG National Title Insurance Company. If you don't know what that is, when you buy a house, you see that thing, title insurance, you're like, what the hell is that? She works for that company. Basically, when things get complicated, I reach out to her and say, please help me. So Lisa, anything else you would like to add to yourself?
No, but I at one point I was where Sean is. I was in practice down on the Cape for a while, and then came over to what we call the dark side, which is title insurance. And if anybody ever says to you that title insurance is not necessary or you don't need it, don't listen to them. But we could have a whole other hour discussion about that one. We won't get into that.
Probably.
Right, exactly, because we
Yeah.
have some more exciting things to talk to you guys about today.
Yes. Yeah, it's pretty low bar, but yeah, it's definitely more exciting than the topics of title insurance. So just an overview of what we're talking about for the next hour. We have the expanded FinCen geographic targeting order, the FinCen Corporate Transparency Act, how it applies to condos. And then the big topic is the real estate broker commissions, this class action lawsuits against realtors and brokers and their groups. So we'll dive into all those. So start with that first subject. Basically, we said FinCen. What is FinCen?
What is FinCen? I know. I should say at this point, it's probably a topic that's near and dear to my heart. Ugh, I hate to say it like that, but it's coming up a lot. So everybody asks, what is FinCen? So FinCen it's a bureau of the U.S. Treasury, created in 1990. As the slide says, mission is to, and I'll read it just for the sake so you get it, safeguard the financial system from illicit use and combat money laundering and promote national security through the collection, analysis, and dissemination of financial intelligence, strategic use of financial authorities. Well, what does that really mean? What it means is that they're collecting information that they are then going to share with law enforcement officials. The whole idea is that they're trying to catch the bad guys. But they themselves are not trying to catch them. They're going to share the information that they get with law enforcement agencies. So they're really a financial intelligence unit for the United States. They're actually part of the Egmont Group, which is an international group of FIUs that share information and cooperate with each other to request information, disseminate information, disclose financial information. It's not like they're disclosing the information of the normal everyday Joe Blow, but they are really looking to stop money laundering. And yes, we are recording this if you haven't, so I'm sure that Sean's office can share this with you guys later on. So really what they're doing is they're following the money, like Jerry Maguire, show me the money. They're really looking to follow that trail. Let's find out who's dropping the TVs out of the back of the truck in the middle of the night. I know that sounds kind of mundane, or back in the day, the mob, but they're looking for that information, whether it's to stop terrorism, to stop drug cartels, or just to find the bad guys. Sean, have you had to do any reporting under the GTOs yet? And we'll get to the GTOs.
Yeah, no, I've done a few. None of the new order yet. I came close to having to do one, but the sales price wasn't high enough, which I know is kind of shocking with house prices the way they are. But it's pretty. Most of mine, when I file it, it's really just that small time house flipper who just flips a couple of houses a year, just owns an LLC. There's obviously nothing shady about that.
Right.
That's not really who they're looking for, but it kind it obviously encompasses those small time flippers who just do an LLC. Probably heard the expression one door, one LLC, one door, one entity. So they just formed an LLC, they bought the property in that and flip it.
Single purpose. Right.
Yeah. So
Right,
even though that LLC is probably only up for a year, maybe a year and a half, if they need some extra time selling the house once it's flipped, you know, they're kind of encompassed in that, that targeting order just because of where
right,
they live and just
right,
someone told they heard, hey, just form an LLC if you're flipping a house,
right.
which is good advice, but you know,
But
and
there's another level to that. If you're forming an LLC, and this is where we want to let you all know, anybody who's listening that does that sort of work, you're going to have, and this is where FinCen becomes important to you because of these orders that we're going to get to on the next slide. There is another level of reporting that you need to be aware of besides the, filing with the Secretary of State every year to keep your LLC updated and in good standing, and paying your $500 or $525. There's no financial reporting here with the FinCen, but you're sharing information that you wouldn't normally think that you were going to share, especially if you are a member of an LLC. Let's go to the next slide, Sean, and see, and we'll share with them what they need to share.
there we go.
So on these GTOs, basically the under the Bank Secrecy Act, Title III of the U.S. Patriot Act of 2001, if anybody's really interested, the Secretary of Treasury can issue regulations that require banks and other types of financial institutions like title insurance companies to establish what they call AMLs, or anti-money laundering programs, including the filing of reports, which is where we're getting into next, that are useful, they say, in the criminal, tax, and regulatory investigations that they conduct, including intelligence and counterterrorism matters. So that's where these GTOs come into place. So what is a GTO? Well, it's called a geographic targeting order. It's done under 31 USC section 5326A. Again, if anybody's really interested in the statutory reference. And again, just like I was talking about before, it's about generating leads for local law enforcement, collecting the information to share with the FBI, the Secret Service, local police, state police, whatever institutions there might be, so that the bad guys can be caught. So it requires, well, I should say that the first GTOs were actually issued, interestingly enough, for armored cars. Can you imagine? Armored cars and other common carriers of currency. They were looking for currency that was crossing the border between Mexico and California and Texas. So they were looking for all of that type of information. And then other GTOs were later issued concentrating on the fashion districts in Los Angeles, of all places. You're like, fashion? Well, again, we get to sort of like the TVs falling off the back of the truck. Well, no, it's called the bad guys, the illicit parties, I'll call it that way, going in and saying, okay, I want to buy all those dresses off the rack. Here's some cash. So they're looking for cash transactions. It's really where it comes down to. So for real estate, the first GTOs were issued in 2016 for New York City and Miami transactions. After there were some concerns raised, as I said, that all cash purchases were taking place and by individuals that were attempting to hide their assets. Makes sense. And identity by purchasing high-end residential properties through opaque structures like LLCs, where the members aren't always known. Here in Massachusetts and most other places, there's no requirement in the registration when you're registering with the state to disclose who the members are, so who the real owners are of those entities. So they found that there were some bad guys hiding behind this level of this LLC. So they issued these GTOs to try and find out really who the true owners were. And then GTOs got expanded and they get renewed every 6 months. Significantly expanded in 2018, where Massachusetts property became involved, they would expand it to the different entities as well as then the different states or counties that were involved, with the original GTO order for Massachusetts issued, as I said, in 2018. So what does the GTO require? It requires a covered business, that's the title insurance company, to collect and report certain information regarding business persons involved in covered transactions or certain transactions, which we'll get to in a minute, taking place in certain geographical locations in the United States, and that has to be done within 30 days following the transaction. Now, there are high fines if you don't comply, which is why the title insurance companies actually put the burden back on their agents, because they're the ones that know, the agents are the ones that know the intricacies of the transaction. So that means that in Sean's case, as we were talking about a little before, Sean's office is responsible for reporting that transaction. You know, there's a way to do it, and we'll get to that in another slide or two, but, you know, for all intents and purposes, the title insurance agents are an arm of the title insurance company, and that is why they are then the responsible party, or also covered under that covered business definition. The current order actually went even further and expanded to additional counties here in Massachusetts, and that order started October 22nd and goes through April 18th, 2024. You know, and when they first came out, really, we would go, well, I wonder if they're going to go away at the end of the 6 months. No, they're just going to continue to expand. I wouldn't be surprised if eventually they will cover most every state and major city in the United States. Because the first GTO actually here in Massachusetts was confidential. We were restricted from even telling our agents what it said and why the information was being collected. It just said all we were able to do was tell our agents, we need this information. This is what you need to provide to us. You need to give it to us within 30 days. Why? We can't tell you. So think of how difficult that is when you're representing a buyer in a transaction, saying, okay, well, I need all of this information from you. I need a copy of your driver's license, and buyer, because usually you're looking for that information from the seller, right? Because you're wanting to make sure that it is the person who's selling the property. Now you're looking for the information from the buyer. Oh yes, I need your driver's license, I need your social security number, and I need your address. Oh yeah, and I also need, if you have more than a 25% ownership interest in this LLC, is there anybody that does? Oh yeah, I need their information too. But I'm a member. I don't need to disclose my information to anybody. Yes, you do. You need to now disclose it to FinCen. It was difficult for agents to explain that without knowing why. It was terrible.
And you know, that's kind of the purpose of being a member and not a manager. So
right.
you're on public record, no one knows about it.
Right.
But you know, my default whenever, you know, there's something that seems silly to do, I just blame the bank. Yeah, the bank's making us do it. Just blame the bank.
Well, what we were talking about when we were preparing for this webinar, we were talking about closings, and what did we say? Most of the forms, you know, yep, there's the note, the mortgage, the CD.
Yeah,
you know,
the main ones and everything else.
And everything else is, oh yeah, well, it's there. You know, yes, I'll explain to you, obviously, but it's there because somebody got sued for something.
Yep,
same sort of thing.
much.
And the bank is making me do it. The bank is making me sign this, right? So for current covered transaction, so what's a current transaction? We went over who a current, who the covered party is, but who's the covered transaction? So it has to meet all of these requirements. So it has to be a purchase of a residential property, 1 to 4 family. That includes co-ops, condos, and it has to be located in a covered geographic area. We'll show you a slide on that in just a second. It has to be a purchase price of $300,000 or more. And you say, wow, that's not really a high level. As Sean was saying before, you know, yeah, you can have some under that amount. Some condos go for that. But what's really happening is they're trying to collect that really important information. Purchase made without a bank loan by a financial institution. Now, what this means is a bank that is required to have AML or anti-money laundering process in place. So does a bank loan by a financial institution, does that include a hard money lender? No, it doesn't. So a lot of most of the transactions when you have a hard money lender are going to have to be reported, especially if it's not 100% financing and the purchase is using or being paid with cash, cashier's check, certified check, traveler's check, personal check, business check, money order, funds transfer, or virtual currency. Not that's not happening a lot anymore. But if you've completed the sale between October 22nd and 2023 up through April 18th, 2024, you have to report. And the reporting requirement is only if the purchaser is a legal business entity. So it doesn't apply if you're an individual purchasing, doesn't apply if you're a trust or trustee of a trust, doesn't apply, in fact, 1031 entities. The entities are formed by a 1031 company in order to purchase a property in a 1031 exchange are also exempt. So if you're an LLC, a corporation, or a partnership, most times you're going to have to report. So let's just show them, Sean, where the covered transactions are. You have to be for Massachusetts, and we've got all the different geographic areas here, just in case anybody's interested. But for Massachusetts, Suffolk, Middlesex, Bristol, Essex, Norfolk, and Plymouth. So the starred ones are ones that were just added in this current GTO. But think of it, you're looking at the entire eastern part of Massachusetts, except for the Cape, Martha's Vineyard, and Nantucket. Why? Well, the reason that these are chosen, and this is what's really interesting, is that in the sharing of information between the law enforcement and FinCen, FinCen has found that there has been a ramp up of forgery, illicit activity, seller fraud in these counties. So that's why they have now added these counties to the current geographic areas. So it's really kind of interesting when you think about it, that we pass around to our agents all the time about how important it is to make sure that they identify who the seller is and the amount of seller fraud and vacant land fraud that has been happening over the last year or so has really, really increased. And I can really see now why these counties were actually added to the order. So I already sort of went through the type of information that needs to be reported. You're looking at the identity of the agent, the title agent, the person who's submitting the form, information regarding the transaction, purchase price, address, whether it's a residential commercial transaction. Remember, just because it's 1 to 4 family residential property doesn't mean that it is actually going to be lived in by that person. So it's really meant for investment property. The type of entity that's purchasing, type of funds that were used, information about who's signing the docs on behalf of the entity. So if we're talking about an LLC, we're talking about the manager. If we're talking about a corporation, we're talking about the president or vice president, or even treasurer of that corporation. Identity of the purchasing entity, and then, as I mentioned earlier, information regarding a beneficial owner who owns a 25% or more interest in the entity. I know a lot of members in an LLC that are not going to be happy about this, but as I said earlier, the fines are hefty if you don't comply with it. So make sure you give that information to Sean or whoever's representing you, because he has to then send in this form. They can either, as a reporting agent, you can either send in this form to your title insurance company, and the title insurance company takes care of it, or you can get a FinCen login and you can report it yourself. I understand, though, that is it's a pretty onerous task because the online form is not great. So send it into your title insurance company. Sean, send it into your title insurance company. and we can go from
I
there.
always choose the route of less work, so that's not a problem. And yeah, I mean, most of the information on here we have access to. It's already provided, and even if this wasn't in existence,
Right.
obviously it's the other members is probably is a partial part we might not be privy to, but if we're issuing title insurance, guaranteeing title, typically there's some sort of resolution signed by members, of the LLC anyways. But now we are sharing with a third party. Just what happens to be a third party is the federal government. No big deal. But yeah, so we it's an additional step, but it's really nothing too major on our part.
It's not that bad. It's not that bad. I think in the beginning when they first came out, it was just more a matter of explaining to your client why you needed information from somebody that may not even be at the closing table, because those members aren't always at the closing table, right? So it's and closing on the transaction without this information and then relying on people to give it to you afterwards, not such a good idea, because oftentimes they won't give it to you. But the GTOs were really only the first part of this AML structure that was then passed on to really the general public, or through the agents at least. But now we have the Corporate Transparency Act, which is a little more, I won't say controversial, but a little more, I think it's more onerous. Sean, you want to talk about that a bit?
Yeah, definitely. So, we already kind of described what FinCen is. This is another act that was enacted by Congress back in 2021. Just because laws are enacted doesn't mean they take effect right away. So you see the effective date is January 1st, 2024, which is coming up soon. And just like the targeting order of the GTO we just talked about, is to just kind of combat the money laundering, because real estate is a pretty popular way to, unfortunately launder money. Like we said, you can form an LLC, buy property, and you let it sit there or transfer it over, and boom, you kind of have some kind of clean money there. So, and so, like Lisa mentioned, it's really to deter, terrorism, which I know seems kind of scary, but a lot of our dealings are just with some small time flippers, money laundering, any sort of other type of criminal activity. All right. So you see, there's different people that this will apply to, who has to report. The brief ones are, reporting company, company applicant, who's filing, and or beneficial owner. So we'll go into those a little bit more detail in the next slide.
And they're all defined under the act. So, Sean's going to talk about definitions, and this one for a reporting company, very interesting.
Yes. So this is where, really where we think the condominium associations in Massachusetts kind of come into play. So as you can see on the slide, reporting company is any sort of entity that files a document with the Secretary of State. So what the Secretary of State is, that's when you incorporate or register an LLC or a corporation. You give certain information over to them, file, if you have articles of organization, you can file those. And then you can see in bold there, or any similar office under the law of the state which the entity is formed. So as you know, in Massachusetts, unlike a lot of the other states, we have the HOAs. Well, they're not really HOAs. The condominium associations have a declaration of trust if you're in a condominium. So you have the master deed, and then you have the declaration of trust, and then you file that at the registry of deeds, and then you continue to register. As trustees change from time to time, you go ahead and you file those trustee certificates. So every state has a Secretary of State, and they have an office. So by adding those few words in there, or any similar office, we interpret that to be careful. And we think, we believe that now condominium associations in Massachusetts have a obligation to go ahead and file these reports.
So one of the, and just to add to this, I had a discussion sort of with Sean earlier when we were talking about this. after Ed Allcock had come out with an article saying that, oh, yes, this applies to condo associations. And I said, well, I might disagree, but I'm also of the ilk that when it comes to FinCen's like the IRS. You don't want to screw around with them. You want to, especially with the fines as heavy as they are, you want to be conservative. At least I do. Hey, I work for a title insurance company. I'm all about risk. Let's eliminate the risk by being conservative. So, I'm all for over-reporting and then being told later on, no, you didn't have to report, especially since the type of information that we're looking for or they're looking for is really the same type that was found on the GTO. But anyway.
No, and we don't think it was intended to encompass condominiums, but there is an exempt list of certain entities that are exempt, and unfortunately condominiums aren't explicitly on there. So by default, just to be safe, we do think as of right now, we know as of right now, we are under, condominiums are included in it. They might, once they start getting these, multiple condos, registering, they might say, okay, let's fix this. This is not what we meant. But as of right now, just by the letter of the law itself, better safe than sorry.
Right.
It's not a major ask or work to do. So just the simple filing can save you a whole bunch of trouble down the road, which, it's better to, protect yourself rather than have to defend yourself. Definitely.
Right. Yes.
So then, we have that other people who need to report, the company applicant, as you can see from the slide here. Pretty much it's anyone for that entity, who exercises control of the filing of the application to, the declaration trust itself, or, those updated trustee certificates of who is, basically running or in control. So as you can see, that applies to reporting companies. That applies, starting of that January 1st date of 2024, which is coming up soon.
Yeah, when it comes to LLCs too, we're often asked as a practitioner, I was often asked to, form an LLC on behalf of my client. Oh, Lisa, my tax professional has advised that I, set up an LLC to take title to this vacation rental that I have down on the Cape. Can you form the LLC for me? Sure, not a problem. Well, by doing that, I am a company applicant. Now that means that my information also has to be reported. Just the one time. So once, not for anything that's reported prior to January, created prior to January 1st, but anything January 1st, 2024 or after, if you are forming it, if you are filing it for your client, or you're filing it for a buyer of property, you are going to need to report your information as well. That was the one that I didn't like.
No, that's not. Yeah, I know.
No, I'm like, no, I don't want to do that. I'm just helping my client.
Yeah, I mean, and I know when you file online, there's that part where it says, file as information. That's obviously you as the attorney if you're doing for your client, but then also you're not the one that's signing down at the bottom. It still has to be signed or signed, right, via the keyboard by who's, whether it's a president or a manager or the signatory for the Secretary of State in the LLC case.
Right.
So whether it depends on the person actually just typing the info in and the contact info for, if the Secretary of State workers have questions, or who to sign the confirmation, or who the confirmation gets sent to, or whether it's that person who technically signs at the bottom.
Right.
So, it is a little confusing. I mean, some people put, their attorneys as the, the signatory for Secretary of State filings.
Right.
So yeah, I mean, just like any law or any regulation, there's a gray area. But I mean, that's, if it wasn't for gray areas, we lawyers wouldn't exist, and the world would be a happier place.
We'd be out of a job if there wasn't a question about things.
Exactly. So next, and this is, I think LLCs, it's pretty, corporations, it's clear, who the beneficial owners are, right? You have the stockholders, so you have the members. But if you belong in a condo, or you're in the trustee board, all throughout the documents, it's talking about, the beneficial interest, right? That's how you dictate who owns the portion of the common areas and everything.
Right.
So you see beneficial owner here is, as we mentioned before, any direct or indirect exercise over the, there's that word substantial control. That's where the lawyers come in. That's one of those terms over the company itself. And then also anyone who owns at least 25% of the ownership interest. Now for the bigger condos, it's probably not going to come in that 25%, for each owner. But if you get those 2, 3, 4 families, it's pretty much going to be every single owner is part of the beneficial interest, right?
That's right. That's right. Yeah, all depending upon that. And this is where it becomes important to look at and say, okay, what is your percentage of beneficial ownership in your condominium? It's going to be more than 25%. You will be reported.
Yeah. And if you're not sure if this is going to apply to your condo association or anything like that, just shoot us an email.
Yep.
We have on our website, we have emails for the attorneys you can email to say, hey, does this apply to me? And someone can reach out to you and just kind of talk to you about that real quick. So I understand, federal government, FinCen, department, DOJ and IRS can be all kind of scary terms. So, if you're starting to get worried or you have any questions, just kind of reach out and we can kind of explain to you a little bit more in detail. And also, if anyone has questions throughout this the webinar, feel free to type them in the chat. We'll try to get to them at the end.
Yeah, we have one question, and I've told the participant that we will answer towards the end. So we're good to go until then. All
right. And, just like with the GTO that Lisa was talking about, what information kind of has to be reported. And it's basically, it's just kind of putting, some, not responsibility, but, a face to, the people who are controlling these entities. I mean, it kind of makes sense. A lot of the big condos, you see the amount of fees that are coming in, the amount of stuff going out. So, that can be millions of dollars, just kind of going through one entity. So, small ones, yeah, probably not. But, the bigger ones, you could definitely see the possibility of, a lot of money going in, a lot of money going out. So, it's not unreasonable or impossible to fathom why, a federal agency looking at money exchanging hands, regardless of what the reason is, might want to take a look at, really what's, who's controlling this at some of the bigger entities.
Right.
And it's basically the same thing over here with, the beneficial owner report. It's going to be where you live, identify, make sure you're a real person, right? That's why you have those, whether it's passport or, driver's license, birth date. But basically, they're going to just make sure you line up in the system they already have. So, it's really nothing crazy that they're asking for out of the ordinary. Basically, there's money involved. They want to know who's touching it, who's controlling it. Like I said, for real estate, it's easy for money to exchange hands and, kind of not know exactly everything that's happening. So.
Oh, and the timelines, fun times.
Yeah. Well, there's obviously a lot of dates here. When the BOI, report has to be filed, beneficial interest, in case you forgot what BOI was already. And then, how often this stuff has to be updated. I mean, as condos, you file the trustee certificates, when you do that, just like most answers with condo law, what do the condo docs say? That's going to be the 1 year, 2 years, 3 years. Sometimes it's just a portion of the board. Sometimes it's the whole board. If you have the staggering terms. So you see here dates, if this information changes, that first date obviously is January 24th. You want to get those things filed by around January 1st, 2024. But, information changes, who's controlling, who's filing documents. And it's not just trustees, but, you also have the property management companies who are,
Right.
You have authorization to sign, the 60 certificates. So, there is, and that document gets filed with the same, government office, the registry of deeds. So, that's part of it as well. So anytime, information is changed, you do another simple reporting, kind of following up.
Right. And one of the things that just changed actually is that for those entities that are formed after January 1, 2024, they originally only had 30 days to file their BOI, but just a few days ago, about a week ago, the final rule came down from FinCen that is giving them actually 90 days. And I think part of this actually is because FinCen hadn't really come out with the forms yet, hadn't come out with really what the process was.
It's kind of like a
they
link
make this
online. Here,
rule,
go here.
right?
Yeah.
Exactly. They make the rule, but then they think, oh, wait, we're making people report something? How are they supposed to do that?
Yeah.
So,
Like I said, all the reporting's online.
yeah.
And I think we've seen, multiple times of government kind of websites taking reporting or requests. A lot of time the website goes down.
Right.
So in that event, especially if they get flooded with, kind of a bunch of condo ones that they
That's
didn't
right.
really anticipate coming, the website could get overloaded, and then what's going to happen there? Probably an extension on the date. But always better safe than sorry.
Yep.
Try not to kick the can down the road. Just get it
Right.
done. Just rip off the band-aid, get it done, so you don't have to worry about it.
And they actually, for the BOI, the GTO, I felt like they were, there's a lack of information. The geographic targeting order that gets sent to each title insurance company gets their own GTO. They basically say the same thing, but all the information that they need is in the GTO. When it comes to the BOIs, the website for FinCen regarding those is actually really helpful. They have a lot of information in there for a lot of different, all of the different entities. They have if there are any exemptions. They have, if you need to file a report, exactly what you need to do. So, reach out to Sean, reach out, check out the website. It's actually, I was actually somewhat impressed that the amount of information to the general public that they had there. So take a look at that. If you've got any other questions, talk to Sean.
All right. And next on to the final topic, and probably the more fun one.
The sexy one, right, Sean?
Yeah, this is the sexy topic.
Sexy one.
This is the headline grabber. So we have Real Estate Broker Commissions, National Association of Realtors, and the Department of Justice. And really what this is there has been a string of class action lawsuits, one particularly here in Massachusetts, and a couple more around the country, with probably, most likely, definitely many more to come. So basically what these lawsuits that we're going to talk about have to do with is the manner in which sellers pay the selling and buyer brokers, in particular in these cases, the buyer brokers. And before we get into that, just before this case and kind of how it works in general, we just have a little example here for you. And basically what happens is, typically, most of the time, almost all the time, what happens or happened, it's kind of up in the air right now, but basically the default, the way it works now is homeowner hires a seller broker, real estate agent. They agree to a commission, usually 5 or 6%, and then they post it up on MLS. And on the MLS is just where you kind of put up listings. So let all the buyer brokers know, hey, come talk to me about this property. And on that listing is a portion that is agreed to already by the seller. And it's it's on the listing. Hey, here's the percentage. You, as the buyer broker who can see this listing, has sole access to the listing. The buyers don't. This is your portion of it. So there was no real kind of, quote unquote, no real kind of negotiating between the seller and what the buyer's broker commission was.
It was just a blanket, blanket put in there. No matter what you did, you were getting this amount.
Yeah, and so basically what these class action lawsuits have done is they said, the policies that the NAR, National Association of Realtors, MLS, all the different brokers was, they were artificially, conspiring to keep all those commissions high. And just a note on, brokers commissions in general. Yeah, I know if you sell a house, you can kind of see, it seems like a staggering amount, but the
They do a
brokers,
lot of
they
work.
definitely do a lot of work. They do a lot of work. And, just like most jobs, if you don't know what the person's doing, it's probably because they're doing the job right. If they did it wrong and a problem comes up, it's probably because they weren't doing their job right. Yeah, I remember when I first, started doing conveyances, I saw how much commissions were, and I was like, oh, that's a lot of money. But then I started doing transactions where there were no real estate agents or brokers involved. And like I would say 90% of the time, problems came up, deals got delayed. So, there's a lot of work, that goes in on both sides. So, just take these kind of with a bit of grain of salt, these case decisions. Because, obviously it's kind of the lawyers and the class action lawsuits, pushing this. So, that's kind of my little 2 cents on the, brokers commissions in general.
Yeah,
I don't know
there's
if you
value. There is value to the work that is done by both the selling agent and the buyer agent. There's a lot of work done by both of them, and they, deserve to be compensated for what they do. And as Sean said, if you don't have a real estate broker involved in a transaction, the amount of work involved, even from the attorney standpoint,
it's awful.
is staggering. Really, I mean, it's the stuff that we would normally do, but calling for water readings and arranging for the home inspector to go in and arranging for all of the things that need to be ordered. And is there a septic? And is we don't have time to always go into town hall and check out everything. Whereas these are things that the brokers do on a daily basis. They know the people at the town, they know that, and all of that, as I said, there's a lot of value to that. And the compensation is warranted. So, just I think we all need to be aware that, yeah, the way that commissions work, it's like, okay, fine. I don't have a problem with that. But yet, we'll see as we talk about some of the cases, how exactly they thought that this was an inflationary scheme. Wasn't really a scheme, but inflationary antitrust, things of that nature, so.
That's we'll start with the main one, the one that really got all the headlines.
Just a couple weeks ago, actually, now.
Yeah, oh yeah, when we started talking about it. So basically, class action lawsuit, bunch of plaintiffs. I think, I forget the time span of this one, but as you know,
Started a while ago.
commissions are high, so it is a lot of money. So even if it's just 5 years, I know one's about 25 years, one of the other cases. Anyone who, basically sold a home in that time span is owed damages. And so they went to trial, and the jury looked at all the facts, looked at, the kind of the process for which commissions are agreed upon, how they're listed, and they came back with a over $1 billion. Was it 1.8? 1.8, right?
1.8 billion. That's with a B. As we were doing the slides, we needed to make sure that we included enough zeros.
There it is.
It was a jury verdict. So, crazy the amount of money. That is nuts. But when you think of it, as Sean said, it's anybody who bought or sold a house, within that area. So this case was in Missouri, right?
Yes.
And so it's in Missouri. It's for all of the different agencies or brokerages that were named. I think there were 7 or 8 of them, and the National Association of Realtors. So think about how many people bought property in Missouri that perhaps qualified and opted in on this class action lawsuit. Crazy.
Missouri, I gotta think at least 7.
Crazy.
At least 7 people.
Oh my gosh, just absolutely crazy.
Yeah, it really is.
A lot of money.
obviously gonna be staggering amounts. So, I think, as we mentioned, the DOJ is kind of getting involved in this. It's kind of on different fronts. Once this verdict kind of came out, it definitely grabbed some headlines, for sure. If you just type in this case, you're gonna see, a bunch of talking heads like you see right here, right now, talking about it. What this means, if anything. I think a lot of the times if you see that staggering amount, it's automatically just going to be a big headliner. Whether basically we see major changes, that's kind of up in the air. But right now the DOJ, because of this this big verdict, looks like they had a previous probe into the practices of how it was being handled, and they're looking to revive that. And there's also a couple instances where they're also trying to, they're sticking their nose and trying to, figure out what they would like to see going forward, especially if there's any settlements or anything like that.
Well, and this obviously is going to be appealed by the National Association of Realtors. If they don't, and the various brokerages, if they don't, they would just be.
Yeah. So now put out a statement saying, they plan to appeal.
Oh, sure.
But even if sometimes appeal is also used as, especially with bigger settlements, as essentially a
way to negotiate,
an additional way to negotiate or settle,
right?
So whether it's just bolstering or which they honestly believe, they didn't do anything wrong. They were providing zealous advocacy for their clients who are buying and selling homes,
right?
And whether any change comes from that, we'll see. Here in Massachusetts, that's where we have the Norfolk case. I think that's how you say it. Versus the MLS PIN. And like I said, it's a very similar lawsuit. Most of these are, especially the ones that are going to be coming out now and already have come out. It's basically just kind of copy and paste, boiler template. Hey, same stuff happened in this region of the country.
In the different states. Yep.
Pay us a bunch of money, please. and if you can see statements from the class action lawyers, they say, it's not really about the money that's getting awarded, but rather fixing a broken system going forward.
Right.
It is what it is. So in this one, basically what you have was MLS PIN. Like I said, that's where you kind of advertise, and the same thing. And on MLS PIN, which is interesting is you weren't allowed to put zero when you're listing the property as a seller broker. You weren't allowed to put zero. You could put $1, but you weren't allowed to put zero.
Yeah, for the amount that the buyer broker would get.
Correct.
Yeah.
So I think, and there is a settlement. It was approved, preliminary approved by the judge in this case. I think there's like a Denisi period where there's additional review. And then also, as I mentioned, this is one of the cases where DOJ is looking to get involved. They asked for more time to review the settlement, kind of add their 2 cents. And, basically kind of what they said was, they're basically just tweaking, how this functions, and it's not really fixing, the heart of what they see. Right. What they see is the problem, if there, really is one.
They see some of the same issues that are alleged to be happening now continuing to happen, even though with the settlement, there's been all of these things that have been worked out between the parties, eliminating the requirement that a seller has to offer compensation to the buyer broker, requiring the seller to provide notice. Seller can make an initial offer, but then the buyer broker can actually reject it. And then that opens up negotiating. So you would think that all of these things would help that process, or at least negate some of the negative aspects of this. But yet, and of course, there's the money. There's the settlement fund. Yeah, exactly. There's always the money, being set up so that they can continue to prosecute against the remaining defendants. But, there's always something else. Always something else. So just, be wary when you see these things, because they're still open. They're still open and still being worked out.
Yeah. And I believe this, I don't know if it's already taken effect, but I think MLS PIN might have already changed the system of how, I think now you can put zero.
I
Uh,
think, yeah, I think some of the different agency, the ones that, all of these MLSs, MLS PIN, MLS, they're all owned. They're kind of brokerage owned. They're investor owned, realtor owned. And the individual realtor associations, like say the Cape and Islands Association of Realtors, the South Shore Realtors, North Shore Realtors, whoever has control over that PIN in that area, have all kind of started to change something that would at least comply with either the NAR settlement or not the NAR settlement, the NAR ruling and or the settlement. They're starting, but because everything is still, DOJ is still looking for more time, right?
yeah, that's what they asked for.
Yeah.
They said we good start, but no, we
Yeah.
want some more. We want more. Uh, you know,
Yes,
exactly.
exactly.
Yeah, yeah, like I said, there's different MLSs. You get the PIN, you get the Cape, but I think which one's more prevalent up down by you on the Cape? Is that MLS Cape, the Cape Cod one, or PIN? I know PIN's kind of become a little more popular down there.
I think PIN, honestly, I think MLS PIN was being used on Cape Cod for a little while. I don't know
Yeah,
if they still are or not, but I know, the last time I got on a Cape and Islands Association of Realtors call was right after the NAR suit, and that's when they um, really started talking about how their interface was going to change.
yeah, and even if all these listing, companies kind of change their ways, change how they're doing things. Unfortunately, it's not really going to protect you from class action lawsuits because
Right.
damage is already
Right.
done.
Somebody's somebody's going to
Allegedly.
want somebody's going to want more.
Yeah,
Yeah.
exactly. Especially when you
Right.
see these kind of insane, crazy numbers.
Right. Right.
They're probably going to be the next asbestos commercials. Do you have about bought in health for the past 30 years? Oh, what's the new one I see all the time? The military camp.
Oh, the
Get text
Lejeune,
messages asked
Camp
if I ever
Lejeune.
served in the military base. I
Yep.
forget which one it is. I'm like, no. Fort Bragg?
Camp, Le-
Fort Bragg?
Camp Lejeune.
Camp
Camp
Lejeune,
Lejeune.
that's it. Camp Lejeune,
Yeah.
that's the one.
Yeah.
Yeah,
Yeah.
no, never been.
Yeah. No, me neither. So as we were saying, DOJ just wants more time and they want, they probably want more money put in the settlement suit, but they still don't feel that it establishes an elaborate enough of a protocol to change how it's being done. So we'll see. We'll see. What do we think, Sean, is going to happen? What should buyers expect going forward? What do you think?
I mean, it's because these cases are so new, we don't really have, the DOJ full involvement yet. There's still a bunch of cases going on.
Yeah.
Do I think you're gonna see anything? Probably not. I mean, you do have the portion where, the seller and buyers can then negotiate kind of the broker's fee.
Hmm.
If there is a little back and forth on that. So I mean, it's not, you can put zero when listing the property for a buyer commission and then kind of negotiate it. But I mean, the whole a good purpose of the higher broker commission is that it's going to drive traffic towards your house when you're selling it. So
Right.
the
Right.
higher your commission, brokers, they're human, obviously if a bigger check, it's going to be like, yeah, well, look at this house. And, that is kind of the problem. But I don't really see an adjustment on the system that would fix,
Right.
human
Right.
nature. I
Right.
mean, it kind of is what it is, but I don't really see much change right now, but this is going to be changing probably month to month. People continue to talk about it probably month to month until all these are
Right.
done. Especially, the Spitzer Burnett was the first one to come to a full trial. The next one coming up is the Moral.
Hmm.
The numbers in that are insane. I don't have them right in front of me, but yeah, that Moral is probably the next big one to come.
It's crazy.
The settlement with trial.
I just look at all of these. It's just the
Yeah,
amount of money that they're talking about. And I read an article that, NAR has to worry about, are they going to go bankrupt and having to pay all these settlements? What are they going to do? What are
yeah,
they going to do?
and they'll need a bankruptcy plan, and then they'll have to be approved by the Supreme Court of the United States, and just
Right.
like where
Right.
Purdue Pharma is right now.
Yeah.
So, not that I'm saying they did anything bad, Purdue Pharma. Let's get that straight.
No.
That's not that. The only comparison was in the process comparison, not of the
Right.
acts.
Right. Well, we're coming to the end of the hour already. It has seemed to go very quickly. But we do have some questions that we wanted to answer. So what about, so this goes back to the GTO. What about if it is, say, a 2 or 3 condos that are under 300,000 each, but the total is over 300? So that, if it's part of one transaction, multiple properties in one transaction, then it requires GTO reporting, requires that transaction to be reported.
Yeah, especially if you're doing it on one instrument, right? If you're doing one
Right.
deed.
Yeah.
But I mean, if you're doing
Or even one mortgage, one recording, well, mortgage doesn't really, but I would say, I would look at it, even if it's not in one instrument, if it's in one purchase and sale agreement. So say you've got a property, or say you've got 3 properties, one in Suffolk, one in Middlesex, and one in Plymouth. And they're all in there. Well, Cape doesn't count. So exactly. I guess, that does, beg the question, do I then enter into a separate agreement for the one on the Cape, maybe allocate the majority, say it's 900,000. Say it was like $300,000 each. Do I allocate then the majority? I'm not telling anybody this is how to avoid GTO reporting, but say I allocate the majority of the purchase price to the condo on the Cape. So that would then make, say, $299,000 each for the property in Suffolk and the one in Middlesex. Well, then reporting's not required because it's under the $300,000 threshold.
Yeah, I mean, but most buyers probably aren't going to know about the starting order until
they're sitting at the table.
Until it's in the table, or if they have a prepared closing attorney a couple days before.
Right.
So it might be a little hard to go back and amend the purchase and sale agreement or change it.
Right.
Or, but for the amount, unless you want to add something, but
right.
there's really not much work on your part as the buyer to just comply. It's really your closing attorney is going to file one piece of paperwork, and
yeah.
As long as you're not doing anything shady, you're fine.
So we mentioned that the 1031 entity is exempt. Do you mean only a specific 1031 entity form for, say, a reverse exchange, or are all 1031 transactions exempt? No, not all 1031 transactions. If you've got a single purpose entity that you're forming in order so that your transaction can apply, say, in this question, for a reverse exchange, that entity, that part of the transaction is exempt from the reporting. If not all 1031 transactions, just those, because remember, you're talking about a buyer, so you're forming one to do the reverse. If you're doing a forward going exchange and that LLC is, selling and then buying, within that exchange period, that buying entity, if it's an LLC and the transaction is over 300,000, then yes, if it is a covered transaction.
Yeah, I think there's kind of good reason for that. If you're doing the 1031, you're kind of more deeply involved with the IRS because you are applying. Right. You're already applying, right, for covered under that, that kind of safe harbor exclusion, for the taxes. So you're already kind of providing that info. So it makes sense. Why would you then go ahead and just send that kind of same info over to someone else?
Exactly.
Like, yeah.
So where another question, where can one get the forms to file and where to file them? I'm assuming, since we're at the time of the hour that this question was asked, you're talking about the BOI report. I would go to the website, just go to fincen.com or I think it's .org. I'm honestly not sure now.
Could be a .gov.
It could be a .gov. That's right.
It's definitely not a net though. It's not a net.
No, it's not a net or a .us or anything like that. But I would go to the website or call Sean's office. They can help you with that.
We also have a link on our website. You can kind of just put in some general condo info and then we can get the ball rolling on that. Or like I said, just call if you have just
their phone number is on the bottom of each of the slides here. And will your screens be available? You talk to Sean's office. I'm sure they're happy
so
to
that'll all
share
get
those
uploaded right onto the website. We have a little tab for webinars. So basically, there'll be a transcript. You can replay this, listen to my dumb voice all over again. if you want, or if you don't want my voice, you can just look at the slides and use your imagination. But yeah.
So thank you everyone for attending. We had great attendance today. We appreciate your time. We know you guys are busy, so thanks so much. And Sean, this was awesome. Thank you for inviting me on to attend.
Absolutely. Hope you had fun.
It was a blast.
Yeah.
Have a great day, everybody.
Take care, everyone.
All right. Excellent.
Definitely.
That was pretty good.
Yeah.
Everybody's
It's like
thinking,
quicker than you think.
yeah. Oh yeah, it goes by quick. It goes by quick.